Okay, let us begin. We are taking up today commercial general liability insurance. Commercial general liability insurance. This policy is also known by the name of comprehensive general liability insurance. In fact, this is one policy which covers third party liabilities arising from various business operations, be it premises, products, completed operations, advertising, and personal injuries. They are all part of the coverage. Now, this comprehensive general liability or commercial general liability insurance policy operates as a combination of public liability and product liability. Means two major liability products are the combination under this policy, and it also offers various other covers in the standard wordings like personal injury, advertising injury, and tenant liability. So the major coverage relates to the combination of public liability and product liability. What does the CGL covers? Bodily injury and property damage. Coverage, public liability, product liability. Completed operations, even advertising injuries and tenants liability are also part of the policy. So as far as the coverage is concerned, it covers third party legal liability arising out of accidents causing bodily injury. Bodily injury here means physical bodily injury. Physical bodily injury. Maybe sickness or disease sustained by a person, including death resulting from any of these at any time. So that will come under the bodily injury category. Property damage means physical injury to tangible property. Tangible means which is in the existence, which can be seen, which is physically available. And it also covers the legal defense cost. So as far as the coverage of policy is concerned, under the commercial general liability insurance, also known as the comprehensive general liability insurance, it's a combination of public liability insurance as well as product liability insurance. But in addition, this also includes personal injury, advertising injury, and tenant liability. So this is the coverage of the policy. Here, one most important thing is, when the bodily injury or property damage occurring away from the premises, the insured owns or rents and arising out of the insured product or insured work except under these two circumstances, products that are still in the insured physical possession or work that has not been completed or abandoned. So these two are important things. Otherwise, these are the major exclusions of the policy. Major exclusions for bodily injury or property damage cover arising under general liability and product liability. Why they are major? Because these are the common risks which are available in every place, in every organization, like workman compensation liability, employer's liability, assumption of liability, aircraft or motor vehicle liability. They are covered under different policies. And this is the reason they are excluded from this policy. Even damage to the property is covered under the fire policy, so that is also part of the another policy. Expected or intended bodily injury or third party damage, damage to own property, damage to own employee, damage to impaired property. They are the specific exclusion of this policy. Neither payable under the public liability insurance policy part nor payable under the product liability insurance policy part, though both are the combinations of this policy. Both are covered under this policy. So as far as the coverage is concerned of the personal and advertising injury cover, because that is also part of the policy. This is an additional coverage under the CGL policy known as the personal and advertising injury cover. What coverage does this section provide? False arrest, detention or imprisonment, malicious prosecution, wrongful entry into or eviction of a person from a room, dwelling or premises that the person occupies. Means in that case it becomes nuisance. Means it is the infringement of others' right. Oral or written publication of material that slanders or libel a person or organization or distorts a person's organizational code. Both these slanders or libels are kind of defamation, insulting. So any word or statement which is humiliating the other person is coming under the category of standards or slanders or libels. Oral or written publication of material that violates a person's right of privacy. Say in advertising, the impact depends on the contents of the advertisements. If they are hurting anyone, if they are in the infringement of the rights of anyone, if they are humiliating to anyone, they becomes the reason to sue. The other person who is feeling humiliated, who is feeling his rights are violated, he can file a case. He can claim the compensation. And for such things, the compensation is unlimited. If you have insulted any person in advertisements or any company or any organization, you have made any such comments, any such remark, any such statement, or even any such song which is humiliating, which is insulting the other party, which is infringing the rights of other persons, he can sue. And the demand for compensation could be unlimited, in lakhs or crores even. Simultaneously, misappropriation or advertising ideas of a style of doing the business. Sometimes, see, if you are copying the contents of others, that is also the violation of rights. If you are stealing the songs and contents of others, that is also the violation of rights. So this is the way personal and advertising injury cover will provide the compensation. Because malicious prosecution is there. False arrest, detention or imprisonment could be there because of these things. False arrest, detention or imprisonment could be there. These, even on the social media, if such kinds are published, if such contents are placed, still they are subject to prosecution. So oral or written publication of material that is insulting or humiliating to any person is a cause for prosecution. So this commercial general liability insurance coverage area includes bodily injury and property damage liability, personal and advertising injury liability, and even medical expenses for the injuries and the damages. Then the major exclusions for personal advertising injury section. This is one section which is in addition to the public liability and product liability. But this is part of the policy. So this is covered. And this is separately providing the coverage here. This is separately providing the exclusions here. While talking of exclusions, under the personal or advertising injury, this policy will not pay the compensation in case it is arising out of oral or written publication material if done by or at the discretion of the insured with knowledge of its falsity. If it is done by the insured with knowledge that it is false, it is wrong, it is copied, this content is stolen, if this is already in the knowledge and still if it is published, then the insurance company will not pay the claim. Insurance company will say this is your deliberate efforts. You have done it intentionally, just to seek the claim from the insurance company. Similarly, arising out of oral or written publication of material whose first publication took place before the beginning of a policy period. If the insured has done all these things before taking the policy, he has already done it, but now he has been sued for that. Now the action is taken against him. Now there is a court case against him for the compensation. Insurance company will not pay because this is an act of publication which took place before the beginning of the policy period. That means it is not covered under the policy. And arising out of the willful violation of a penal, statute or ordinance committed by or with the consent of the insured. If the insured knows, as per the provisions of this law or this statute or this ordinance or this circular or this government provision, he should not do it. But still if it is doing, it means it is a willful violation. So for that willful violation the company will not pay. And for which the insured has assumed liability in a contract or agreement. So this exclusion does not apply to liability for damages that the insured would have in the absence of the contract or agreement. If under any agreement the insured is taking a wrong action against any third person, insurance company will not pay the liability because that is the exclusion of the policy. So this exclusion list is clear and it is very long because this advertisement injury or even the personal injury which is defined under the coverage that the insurance company will pay only for the false arrest, detention or imprisonment or malicious prosecution and wrongful entry and oral and written publication of material that slanders or libel and misrepresentation. Other than that, insurance company is not liable. So under this personal and advertising injury section, the coverage is very limited. So here again, completed operations, advertising injury, personal injury, medical payment, product liability and property damage are covered because they are part of the public liability and the product liability section. One more liability covered under this CGL is tenant's legal liability. Now the coverage is very limited in the sense this policy will pay or this insurance applies only to the property damage to premises rented to you. Subject to that, the premises are covered. Premises is covered and it is rented. In that case, the insurance applies only to the property damage, which occurs during the policy period. So the property damage must be caused by occurrence. The occurrence must have taken place in coverage territory. If any insured property is let out, rented, and during the policy period, if there is any damage to that property, that is called property damage, to that extent only this policy will pay the compensation under this tenant legal liability section. Because this property damage is to the rented property. So this is one more section covered under the policy. Here again certain exclusions are there which are also defined, like the intended or expected From the standpoint of the insured, if there is any such property damage, that is excluded. Property damage for the insured is for which the insured is obliged to pay by reason of the assumption of liability in a contract of agreement, that is also not covered. Property damage for wear and tear and gradual deterioration, normal upkeep, latent defect or inherent vice are also not paid. There are also exclusions of the policy. Now, how the CGL premium is based on? Because this policy has to be issued to any individual, to any organization. How the premium will be taken? First of all, the territory and jurisdiction has to be defined. Territory, normally what we are giving is India. Jurisdiction we are giving is India, except in certain cases where the specific demand is there. So the CGL form are accepted for India, otherwise the worldwide, excluding USA, Canada, and worldwide if available as per the RITT. That means three options are there for both territory and jurisdiction. They can be given either for India or worldwide excluding US and Canada. But at times, this coverage is as per the provisions of the RITT we have with reinsurance. Because if they are not permitting to give the worldwide coverage, we are restricting it. If they are not permitting to give the worldwide coverage except to US and Canada, we are restricting it. In that case, the only option left out is territory and jurisdiction for India. But as on date, it is available for all. So coverage opted for coverage A, that is bodily injury and property damage arising from general liability, that is product liability, and product and completed operation. So this is coverage A. Here the premium would be for this category, coverage A, bodily injury and property damage. Coverage B, personal and advertising injury. Coverage C, tenants and legal liability. Coverage D, E and O. Although policy has scope to cover but RI exclusions, therefore not covered. We are not providing it. Then medical payment, and then fire damage to premises rented or occupied by the insured. So they are also restricted. Now what is important when we are giving the premium? The 5 important factors to be considered by the underwriters before issuance of this policy are risk occupancy, limit of indemnity. Limit of indemnity will be selected as per AOA and AOY ratio selected by the insured. Then turnover, more relevant for product and completed operations liability. And then add-ons selected. So CGL premium is based on these factors. Whatever is available, that can be issued. What is restricted cannot be issued. But these 5 factors will play the key role in deciding the premium and acceptance of coverage, and these are risk occupancy, limit of indemnity, limit of AOA and AOY ratio selected, and turnover and add-ons. Then who can take this policy? Normally, industries and business houses take this policy. And these may be retail stores, restaurants, manufacturers, healthcare providers, technology companies. But at times certain professionals also demand it, like contractors and construction workers, consultants and freelancers, event planners, fitness instructors, photographers. So their proposals are considered on the merits, case-to-case basis. But for industries and businesses, it is available easily. Now, limits of insurance. What limit of insurance is applicable to this? because the limit of liability shown in the declaration and rules below fix the most first, regardless of the number, who are the insured, then claim made or actions brought for, and third persons or organizations making claim or bringing action. Who could be? That has to be defined, that has to be decided before giving the policy. Because the claim made by any other person will not be considered. Suppose the claim made is by the third party. The third party is allowed, any person is third party. But who would be the insured? Organization, individual, that has to be decided in the proposal form itself. Then the aggregate limit is the most he will pay for the sum. But what does this aggregate limit would be? First, compensatory damages under coverage A. Coverage A is meant for bodily injury and property damage liability. That is arising out of the product's completed operations hazards. So this will be the first component of the aggregate limit. Compensatory damages under coverage A. Then compensatory damages under coverage B. This B includes personal and advertising injury liability. Then compensatory damages under coverage C. C includes tenant's legal liability. Then compensatory damages under coverage D, if it is given as per the TT, otherwise not. And D stands for errors and omissions liability. So this will make the aggregate liability. And then comes to the limits. On each occurrence limit is the most will pay for the sum on the compensatory damages under coverage A and B. So this will decide the limit of insurance. Now inbuilt coverage under CGL. Some additional inbuilt coverage is there. What is that? Act of God perils. Policy covers the third party legal liability arising out of the earthquake, flood, tsunami, storm, etc. They are covered. Food and beverage covers are also included. Third party legal liability arising out of food and beverage whilst in the designated premises. This is also inbuilt, no extra premium charge for that. Lift liability, third party bodily injury and property damage arising out of the lift or escalators. This is also covered. And then extra facilities. What are these? Third party bodily injury, property damage arising out of facilities such as gym, sports room, spa, swimming pool. So they are also covered additionally. Now, this is the coverage and exclusions of the policy. What will be the aggregate liability under this policy? That is also clear. Now certain examples will make it more clear. Say suppose product liability claims are there. Crop damages of farmers due to use of insured product pesticides. Some manufacturer is making the pesticides which is defective or which has caused the crop damages to the farmers. Farmers filed case on that pesticide manufacturer. Court awarded 72 lakh compensation plus defense and damages. And that was paid because the defective product was there. Secondly, IT company office gutted by fire due to defective batteries in UPS. The insured, who were the manufacturers of the batteries and UPS, they supplied the batteries and UPS to a IT company. Now, due to the use of those batteries and UPS, that IT company office gutted by fire, that was burned to ashes. Estimated loss was 5.2 crores. Because the property damage to third party was there, machinery due to use of defective insured products was there, the loss was paid. including all cost and legal expenses. It was paid for 6.42 crores because of the defective products. Certain other examples, very important examples you can see. Tomato sauce. Tomato sauce manufacturer, what he did? Tomato sauce got damaged at the Nestle's plant due to defective pump used to pack sauce. Pump manufacturer was liable to pay 2.5 million. Nestle is a tomato sauce manufacturer. Some other products also they are manufacturing. But when they used the defective pumps, गूदा जिसको आप बोलते हैं, जिससे वो बनता है टोमेटो सॉस, वो डिफेक्ट था, सड़ा हुआ होगा, maybe it is time barred or rotten. So they have to pay 2.5 million compensation for that because this is the loss which has directly caused the bodily injury and the property damages to the people. Not property damages but bodily injury to the people. If we are using such a defective tomato sauce, people may die, people may suffer the sickness and diseases. In that case, compensation has to be paid. The court has awarded 2.5 million compensation. In another case, 89 people choked to death in a Kolkata hospital when a smoke from the fire in the basement spread through the central AC duct. So here it is the negligence of the hospital. Here again the compensation was in millions. In another example, one person died because of lift crash in Delhi. Lift crash in Delhi. Lift manufacturer was asked to pay the compensation of around 10 million. These are the examples of the product liability. Because of the defective products, when there are bodily injury, the compensation has been decided by the court of law. Manufacturers or the producers have to pay the compensation under the commercial general liability policy. Because commercial general liability policy is a combination of the public liability as well as product liability. In addition, 3 additional risks are there, which includes the personal and advertising injury and tenant liability also. So the product liability section is paying the maximum compensation because of the defective products. So here even the lift manufacturer is liable to pay 10 million compensation because the person died because of the lift crash in Delhi. In another example, 19 persons including 13 children died in a fire that raked through an upscale shopping mall in Doha, Qatar. This is not the example of India, but when the coverage given is worldwide or coverage given is worldwide excluding US and Canada, in that case our policy also has to pay the compensation. Because the territory and jurisdiction both are defined in the policy. If they are allowed on demand, they are covering the liability even if the incident is taking place beyond the territory of India. So even if the incident has taken place in Doha or Qatar, where 19 persons including 13 children died in a fire, the case was filed on the owner of the shopping mall. Of course, he was liable. In another example, 7-year-old died after falling from the 6th floor of a hotel. When the acrylic tiles he was standing on caved in. Acrylic tiles caved in. 6-year-old boy died falling from that. So the parents will file the case upon the hotel owner, and the hotel owner is liable to pay the compensation. Here, the amount is decided on the basis of the AOA and AOY. If any one accident limit selected by the insured, if the award or legal liability is within that scope, the compensation will be fully paid by the insurance company. If the compensation awarded by the court of law is more than that, in that case, insurance company will pay the compensation to the extent of any one accident limit, and the remaining amount has to be borne by the insured himself. Similar is the case with the tire failure, which lead to death of car passengers. Firestone Company, who is the tire manufacturer. So the defective tire was manufactured, and because of the use of that defective tire, it resulted into the death of the car passengers. So this Firestone Company was asked to pay multi-million compensation to the dependents of those passengers who died because of this tire failure. You may be thinking that how it will be proved that this death is due to the tire failure. This can be proved. This is proved before the court of law. This is proved before the insurance company also by submitting the investigation reports and survey reports and finding the reasons whether this tire manufactured by the company is within the parameters or not, or this is a defective product. It's not that difficult. There is documentary evidence for that, because the court is also not going to award any compensation unless it is proved by the documents that yes, the manufacturer is liable for that, because the product is defective, and product is defective on this ground, and because of that there is injury or death, or there is possibility of injury or death. But the compensation is always awarded only for the actual injuries or deaths of the disabilities, not on the expected or presumption basis. So this is a CGL policy we are also providing. You may be receiving the demands from the brokers. So you can refer, yes, we are providing the commercial general liability policy, which is a combination of our two policies, that is public liability and product liability. But in addition, this will also cover personal injury, advertising injury, and tenants' legal liability. So this is the coverage under this policy. But normally, big organizations take it for a big sum insured, because they always have the fear that if their product is established as defective on any of the reasons, they are liable to pay the compensation in millions and billions, and at the same time the product may be out of the market because of the bad reputation. So they are always afraid, and that is the reason they are taking this policy to pay the huge compensation to the persons who have suffered the loss because of their defective products. So this is a CHGL policy. If you have any questions, you may ask me now. Policy is not complicated, but you may not have solved it, so it may be appearing to you that this is something new. But otherwise, policy is very simple. The only thing is, when you are selling one policy, that is a nice solution. But when you are selling a package policy which is having coverage for few policies and other clauses also, so customers prefer that one, because that will provide a wider coverage and at times will save them from the huge liabilities. So this is the policy now getting popularity because of the demand created by the private insurers in the market. You may also get the proposals for that. Okay, see the mail ID if you have received the test papers. Please confirm if you have received.